of the House Judiciary Committee and the House Human Services Committee, continuing to get educated and have some oversight of the juvenile justice system. Thank you. Upward system on whatever date this is. The 16th. So we're going to
Thursday. That's what all I know.
yes, it is Thursday, the 16th, and we're going to start with the Defender General's office and Marshal Paul. If you could join us, Martha. Thank you for being here.
Thank you for having me. I have a PowerPoint. Let me just get that up on the screen. All right. That looks right. So thank you for having me. I'm going to start by introducing myself. I think I've testified before almost everybody here before, but I'm Marshal Paul. I'm from Bolton, Vermont. I'm the Deputy Defender General and Chief Juvenile Defender for the state of Vermont. I've been working in defense for about a little more than 15 years now, and I've always had a specialty in juvenile defense. I started out practicing as a criminal lawyer in Lamoille and Orleans counties, and then moved over to the central office in Montpelier, splitting my time about 50% between doing criminal appeals at the Supreme Court and doing juvenile cases with a particular focus on incarcerated juveniles. I handled for many years all of the Woodside administrative hearings, and my office continues to play the role of advocate in those hearings that now take place at Red Clover. So that's my background, and I'll jump right into this. So I did watch yesterday's testimony, and I know that there was a lot of discussion about raise the age and potential bills. I'm not going to get into any of that, partially because I'm kind of a rule follower, and so I got a list of questions and kind of built my presentation around the questions. But that said, I am happy to answer anybody's questions about anything. So don't feel like you can't ask me about things that are outside of the presentation. I'm happy to talk about anything related to juvenile law. So,
and just so you know, we're going to Tuesday and Wednesday next week, we're going to specifically focus on the raise the age issue, and we'll be reaching out to get you back in sometime then as well.
All right, fantastic. So to start off with, I wanted to make a chart that really shows sort of what I would call the granularity of our system. We have, when it comes to juvenile jurisdiction, when I say juvenile jurisdiction, what I'm specifically talking about is the decisions about what types of cases and what types of defendants will have their cases heard in juvenile court versus those that will have their cases heard in criminal court. And you've seen a few different versions of charts that delineate, who is seen in what court. But I think the versions you've seen so far have been accurate but simplified. And I wanted to give you one that shows you sort of the full picture, because we've done a lot of work in Vermont over the course of really 30 years of sort of identifying certain age ranges of offenders and certain categories of offense, and really fine tuning, saying, this is a case that we want to start in juvenile court, but we want it to be able to be transferred to criminal court if it's appropriate. Or maybe a year or two later, the case should start in criminal court and then be able to be transferred to juvenile court if it's appropriate. So if you look at the chart, in the far upper left corner, you have the 0 to 10-year-olds who, that white band means they can't be charged for anything. Any offense that's committed by a 5-year-old, 6-year-old, 7-year-old is probably not really a criminal offense or even a delinquent offense. It's probably, if it's serious, it's probably a parenting issue. It's probably something best addressed through the child welfare side of the court system rather than through the delinquency side of the court system. Now, the one exception to that is all the way on the right-hand side, covered up by my name tag, is a category for murder. In Vermont, you can be charged with murder at any age, no matter how young you are. So age 0 to 10, still subject to criminal liability for the one most serious offense we have. And other than that, not subject to liability for anything. Then you get into the 10 to 12-year-olds who,
Okay, just before, so for folks, this is available on the Judiciary website. That's not on Human Services, but if you're looking for it, it is on the Judiciary. Sorry to interrupt.
Thank you.
Mark.
no problem. And so as you go through this and you see this sort of, as you move down to the lower right corner, we're getting to the older youth and we're getting to the more serious offenses. And as you can see, those are the ones where, you know, they start to be treated more like criminal cases. As soon as you get to 14 to 16-year-olds who commit serious violent felonies, they're presumptively criminal cases. They start in the criminal court, and only if the defense is able to meet its burden of proving that a transfer is warranted, can the case be shifted to the juvenile court. That would be all the ones that are in sort of pink, magenta. The ones that are in yellow are cases that start in the juvenile court, but can be transferred up to the criminal court. The ones that are in gray are cases that start in the juvenile court, but there's no prosecutorial discretion. They must be considered for transfer to the criminal court. Then you reach that line that's all blue. That really represents the category of youth who are eligible for youthful offender status, but not eligible for any kind of juvenile status. And then you reach the red line, that's adulthood. That's when you no longer have access to the juvenile court system or the youthful offender system in any way. So I know that's kind of a complicated diagram. It's meant to be. It's a very, like I said, granular system. And I would say that that is, well, it's complicated and it can be difficult for new attorneys to learn. And it definitely looks more complicated than some of the more simplistic juvenile jurisdiction divisions in other states where they just draw a bright line at one age and say, this is adult, this is juvenile. I think ours actually serves us well. We really look at this as sort of a matrix of both maturity and severity of offense. And that's what determines where a case is placed and where it can travel to. So with that,
Can you just very generally describe the felonies that are listed in those different categories?
yes,
Because yesterday we heard a lot about the big 11+3, which is the felonies listed in 5204A. But if you could just briefly describe what those other.
sure. So the 5204A felonies are sort of the classic common law big felonies: murder, manslaughter, arson causing death, sexual assault, no consent, maiming, aggravated assault, aggravated domestic. There's a handful of others, but they fit into that sort of category of serious violent interpersonal offenses. The felonies that are listed in 5201C3 are
And are those the so-called listed crimes?
no, none of these are the listed crimes. Those are listed in, hold on, I think I just lost my connection. The listed crimes are listed in Title 13. They're in the victim's rights section.
Oh, okay. Right.
And the listed offenses are really just a list of offenses for which you are eligible for a victim's advocate. So they are essentially a list of crimes where a victim's advocate is going to be useful. Crimes of an interpersonal nature. So the three lists that we use, the 5204A is the classic list of exclusions. 5201C3 is a smaller list, and
Yeah, I was like, okay, and I was like, well, it's personal style choice. And he goes, yeah. Good talking. I must have got off my feet.
I got the text that my son is not in school. It's the second time he hasn't been in school. I'm not home.
It's
Everything's
about to
falling
hit the
apart.
fan.
Dad's clearly.
How old is he? High school?
13.
13. So
Middle school.
he's at that age where he wants to rebel. That's okay. It's okay. So he's seen how much he can get away with.
Yeah, we'll see.
Is he your oldest?
See when he's repeating seventh grade, how repeat that is.
Yeah. Is he your oldest?
No, he's my youngest.
Oh, he's your.
I have 3 boys.
Oh, okay.
Yeah.
Well, I knew you had the 3, so I wasn't sure if he was at the top or the
No,
bottom.
the other 2 are 19 and 22.
Oh, okay.
They're out of the house already.
So he's loving being
Yeah, it's like I'm a lonely kid.
Yep.
Parentless.
Do what I want. Yeah. My mom's a legislator. I can do whatever I want.
I was hoping that the incentive would be eligible to apply to be a paid next year.
That'd be great.
And so I thought that would be incentive for them to go to school and raise it up. I don't know, it's not working out so far.
That'd be great. I mean, you'd be up here.
I know, what an experience.
It'd be great. I will say that I remember 2 kids that I graduated from that was in 8th grade and did the same thing.
Yeah.
And it was a great experience. I regret not doing it, but at the time I didn't want to go away from home.
Yeah.
Because I remember my parents asked me if I was interested. And I was like, I don't want
Where do
to.
they say if your parents are up here?
They have like a hosting.
Oh, okay, that's
You know,
cool.
I think it's great. I think they're a group of families that just are on rotation and look out for the kids. But yeah, it'd be great for yourself. What an opportunity. And when you're up here, it's,
I know, well, that's why, yeah.
Yeah, and it's like all the.
All right, we're live and everybody can hear us.
Oh my. Not just us.
Confirm.
Not just us.
Confirm.
All right.
All right,
Thank you. Back over to you.
so
Sum up everything you've said.
Oh, God.
I was talking about dispositions and how they are so different from criminal sentencings because they are incredibly individualized. At every disposition hearing, there is a case plan report that is tailored to the individual child and that identifies specifically, here is what services this child needs, and also identifies tailored, like we don't have standard conditions of probation in juvenile court. We have tailored conditions of probation. We write the conditions of probation for each child's situation specifically. And that's really, from my perspective, the magic of juvenile court is the disposition process. It is so unlike criminal sentencing in that it is so focused on identifying needs and meeting those needs. And so I really wanted to highlight that. Post-disposition, if the youth is in custody, so most youth are not in custody post-disposition. Most youth go through disposition, most youth are put on probation, but they're not put in custody. And so, but if a youth is in custody, there's going to be regular permanency hearings, which are hearings to determine essentially, are we doing everything in our power as a state to get this kid out of custody and into a permanent living arrangement? And that's another thing that I think is really differentiates the juvenile system from the adult system, is there's a real focus on successful transitions. These permanency hearings are really focused on, okay, you are going to sort of emerge out of this as a young adult, and what are you emerging into? Have we as a state provided you with educational resources, access to housing resources, access to employment training, all of the things that we can do to try to set a kid up for success as they depart the juvenile justice system. There's also violation of probation hearings, out-of-state placement hearings, other types of hearings that happen after the case has essentially been closed. And that's another real difference between the criminal division and the juvenile division, is at the criminal division, you get sentenced, and in most cases, that's the end of the story. There is no more sort of follow-up after that. In the juvenile court system, there is a lot of follow-up after the disposition. There's sort of constant check-ins to see, are we making the progress we thought we were going to make? And then ultimately, there's a case closure, either at the end of probation term, or if the child has accomplished all the goals that were set out for them, they might get an early discharge.
What's that going?
Yes, thank you. So I apologize. It goes back to number one in the steps of this. This is something that came up yesterday because of the charging decision. It sounds like there's a screening tool that is used, the Yazi. I'm wondering if you could speak to that, because I feel like that leads into if it's charged and goes into the juvenile division, or it could go to these other off ramps. I don't know if you're going to be speaking to that in more detail.
I can answer that. So the Yazi is the screening tool we've been using in Vermont for at least 16 years, because it was there when I started. It's a very, I would say a very good tool in the sense that it is accurate. It's been normed in Vermont using Vermont statistics. And so it's, you know, when we look at the results that the Yazi give, which the Yazi, just so that you know, it's a series of questions broken up into two sections. There's a preliminary section, which is about 35 questions. And then there's a complete Yazi, which adds another, I've forgotten, 40 more questions or so to that list. And it's based on actuarial data. So it's based on looking at cohorts of data and saying, okay, young people who had these characteristics committed offenses at such and such a rate. And so you basically run somebody through this list of questions and ask questions like, some of them are kind of subjective. They ask questions of your parents. They'll ask your parents things like, does your child usually follow the rules at home? They'll look at more objective things. How many police contacts has the child had? And all of that data is fed into a sort of mystery algorithm. This is a privately owned company, and they don't let us see their algorithm. But it's fed into a mystery algorithm that spits out a risk and needs level. It says this is someone who is high risk, high needs, low risk, low needs, or somewhere in between, moderate risk, low need, low risk, moderate need. And it does that in domains. It says, okay, you know, for this kid, the family domain is a real risk. And therefore you're going to need to put some effort into stabilizing this kid's family. Like maybe everything else in this kid's life is actually stable and supportive. But when this kid's at home, they're subject to a really chaotic, really hectic environment that's destabilizing the rest of their behavior. And that's the kind of stuff that the Yazi can identify. And that allows us to really tailor not just charging decisions, but also the disposition. The Yazi is used at two stages. It's used, the preliminary screen is used at the charging decision. And then if you get to disposition, you do the full Yazi, and your disposition is in large part based around what domains the Yazi identifies as areas of strength or areas of need.
A piece that came up, just to follow up on this, is that it is optional for youth that are entering the system. And so my question to you is, what is access? What does access look like? Do you feel like most youth are having the access they need or choosing that as an option? Who is giving it? Because it sounds like Barge does, but that's not until you get to the disposition or past the charging piece of it. So I am just wondering, do youth have the access they need to Yazi so then they could be eligible to go down these diversion paths?
In my experience, the answer is yes. We have certainly had occasions where there have been problems getting youth access to the Yazi, but I would not say there's been any systemic problems. There's been individual cases where for one reason or another, some communication doesn't happen and a kid is not given access to a Yazi, and we're always able to correct that when we identify the problem. But in our experience, we're not having trouble getting kids the Yazi. The reason that it's voluntary and not mandatory is because this is pre-charge. When it's offered pre-charge, you can't really require it of anyone. because they haven't even been charged yet. So they are not subject to court orders yet. And it's more of it's more given as this would be a good idea because it may inform the prosecutor's charging decision. Whereas if they see no Yazzie at all, they're just going to charge you in juvenile court. But if they see a good Yazzie, they might send you to diversion.
And is it your office that would offer it to who?
No,
That's
in
what
fact-
I'm not getting the answer of.
We
Who is
would-
it that?
So I
You're
think,
trying very hard. I know.
no,
And who pays for it?
Yeah. So the short answer on who pays for it is that it's paid for, I believe, by DCF. In terms of who provides it, that differs from county to county. They have contracted providers. And in a lot of counties, it is the barge provider. I don't think it is the barge provider in every single county. If it is, that's new. It used to be sometimes diversion for care programs that were doing it, and sometimes DCF itself that was providing the Yazzie screening. I've had clients go through it all different ways, with a DCF worker, with a barge worker, and with court diversion workers.
But from the Defender General, you're feeling like attorneys they know who is it and can make sure their clients have access to it.
In the disposition context and in the youthful offender context, yes. In the pre-charge Yazzie, the answer is no, and the answer is because at that point, a kid doesn't even have a lawyer assigned, so we would have no idea. We don't even know that the child exists, much less the case and the Yazzie. So that's pre-assignment of counsel.
So who knows to get the Aussie to the kid?
It's usually when the child is cited, they're given instructions that say, call this number and make an appointment to get a Yazzie. If I go to an arraignment and my client has not yet had a Yazzie done, I say, okay, we're gonna get you a Yazzie. And we take care of it within the next week.
Yeah, I mean, mine was just really like who paid for it and if it, the costs were expected to be covered by the family, it was prohibitive, but it sounds like, yeah.
Representative Bishop and then Representative Arsenal.
Thank you. You referenced that the answers to the Yazzie screen are put into the system and the algorithm goes to work. And that's sort of behind the curtain, if you will, proprietary. Is there any sort of, or has there been any sort of quality assessment, if you will, to determine whether the algorithm seems to be matching the needs and hopes for the system?
Yes, I mean, you'd have to talk to DCF to get the details, but part of what Vermont has done is, I think at several points since we've been using the Yazzie, we've had the company that administers the Yazzie norm it to Vermont, meaning sort of take a look at our numbers, take a look at, what you're producing and see, is this actually giving us accurate results? Are the children that you identified as high risk actually turning out to be high risk? Are the children you identified as low risk turning out to be low risk? And that's been done, I know, at a couple of times since we have adopted the Yazzie, and I think it's part of an ongoing. I think they keep norming it as they generate more data. They keep fine tuning it.
I believe there was some reference in testimony yesterday to at least 2 times.
Yeah.
Great, thank you.
So apologies if I'm just not, if you said that 3 times and I'm just not getting it, but I'm back to the Yazzie thing and the options that it presents. And are some kids missing the opportunity to go to pre-charge diversion or, through a restorative process because they might, they're given a phone number when they're cited, and then it sounds like incumbent upon them or a caregiver to initiate that process. So is it fair to say that some kids will miss that first opportunity to not become involved in the juvenile justice system formally?
This is based on my experience, not based on any sort of policy or law. In my experience, what happens is if I walk into court with a new client who I'm just meeting for the first time, and they have not completed a Yazi, and I walk over to the prosecutor and I say, my kid never completed the Yazi, and it's not their fault. So, any kid who's under 16, it requires their parents' involvement anyway to make arrangements and truck them around. And even the ones who are old enough to drive, most of them don't actually have cars. They can't arrange transportation on their own. I've never had a situation where I've gone to a prosecutor and said, hey, my kid never had a chance to take the Yazi, and had the prosecutor say, tough luck, I'm prosecuting because there's no Yazi here. Instead, what they've always said every single time, they have said, okay, give me a Yazi. And I do. And they consider it and they make a decision as to whether or not to divert or prosecute. And is it still an inconvenience? Does it mean that there are some kids they have to go through an arraignment and a little bit more court process before they get that Yazi? Yes. Do I think that the outcomes are substantially different? No.
Okay. And there's also the option that the prosecutor has at the very beginning to send the case directly to a CJC or some other, right, to an alternate.
Yes.
Yeah.
And that's usually an option that, in my experience, prosecutors don't generally even entertain that option without a Yazi, except maybe for some really low-level offenses that, you can tell by the affidavit are really more appropriate for a diversionary process. And then case closes at the end of probation unless the child is discharged early. So then the next question was, what happens for someone under 17 charged with a violent felony not listed in 5204A or 5201C3? And the process here, I'm not going to go into great detail because it's exactly the same as the other process, with the addition of what I highlighted in yellow, which is because if somebody is 16 or 17 years old, and if they're charged with a felony, any felony, this asks a question about violent felonies, but this is not limited to violent felonies. We treat any felony this way. So if a 16 or 17-year-old is charged with any felony, then after that preliminary hearing, the prosecutor may choose to file a motion to transfer the case to the criminal division. And then there would be and I say may, but there's an exception to that. And that is for the offenses listed in 5204 B2A Romanet 1. And those ones, they have to have a transfer hearing, whether the prosecutor requests a transfer hearing or not. So those are the offenses of defacing a serial number on a firearm, straw purchase of a firearm, and I think it's just human trafficking. So those ones, there must be a transfer hearing regardless of what the prosecutor wants. Everything else, all other felonies, it's prosecutorial discretion. They can move to transfer or they can let it sit in juvenile court. If they move to transfer, there's a transfer hearing where the state has to show by a preponderance of the evidence. That tips the scale by even a feather's weight. That public safety and the interest of the community would not be served if the child was treated in the juvenile court. Now, I'm going to skip through these ones pretty quickly because what happens for someone who's 18 who's charged with a misdemeanor is exactly the same as what happens with someone who's 17 or 16 who's charged with a misdemeanor, except for one thing that I forgot to put on the slide and I should have. And that is this: if you go all the way back to slide one of the things that I put in here in each one of these boxes is the age of supervision, which is different than the age of jurisdiction. That's the age that DCF is allowed to supervise you until. And so if you are 16 or 17, DCF is allowed to supervise you for a felony up until the age of 19 and a half. If you are 18 years old at the time that you commit a felony, then DCF is allowed to supervise you until the age of 20 and a half. So it's one additional year of supervision for one additional year of age. But that's the only difference between a 17-year-old and an 18-year-old charged with a misdemeanor. And that's also the same difference for a 17 and an 18-year-old charged with a violent felony not listed in those sections. Again, it is exactly the same scenario with the exception that DCF has one more year of supervision available.
So practical question, as far as if the 18-year-old violates probation and they need to be held, they could be held in an adult prison. Does that happen? Does that change things at all? Do you see that happening? That I don't know if I call it flexibility or there's not a prohibition for that person to be held.
There is an 18-year-old who's charged as a delinquent can't be held in an adult facility for violating their probation. An 18-year-old charged as a youthful offender can be held in an adult facility for violating their probation. An 18-year-old charged as an adult can be held as in an adult facility.
So it does matter on how they're charged.
Oh, absolutely.
I guess I asked that of somebody yesterday and that's not the answer I received. What was the age wasn't how they were charged.
No, it absolutely matters. You can't write a DOC minimus from juvenile court. You can't send a juvenile.
Which is what?
Minimus is a document essentially ordering or defining the terms under which the state takes custody of a person for imprisonment in a criminal jail.
Yeah, Rick's done good now.
Just following up, so is the reason, see if I actually understand what's going on, is the reason that a 18-year-old who's a youthful offender who violates probation could be held is because DOC is the agency who's overseeing the probation, like they're no.
It's not even that, it's just that youthful offender is an adult status. You can only be a youthful offender if you are in adult court qualifying for adult court treatment. And at the end of youthful offender status, if you screw up, you get an adult court sentence. So you are entitled to the rights of adult court and you're entitled to all of the, what may be seen as negative aspects of adult court, which include being locked up in adult facilities. And so it's youthful offender status. I have a slide on it later. It's very much a high stakes, high reward, adult deferred adjudication status. It's not a juvenile court status. Juvenile court, one of the features of juvenile court is that it is entirely separate from the criminal court system. Nothing you do in juvenile court can land you in the criminal court or can land you in a DOC facility. It's very self-contained. That's not true when you reach youthful offender. Youthful offender is more like an adult status that uses the juvenile court as a venue to provide confidentiality and juvenile appropriate services. But it's still really an adult proceeding with adult consequences at the end and adult rights attaching throughout the proceeding.
Let me ask one follow-up question. Is it because of federal law or our law that an 18-year-old as a delinquent can't be held in an adult prison?
That is federal law and our law. Both laws feed into that. So there's a federal law called the Prison Rape Elimination Act, which says that whatever your state defines as a child can't be held in sight or sound contact with adult inmates in an adult facility without jumping through a particularly difficult set of hoops. There's also just in Vermont law, we don't have anything in the juvenile court statutes that would allow a juvenile court judge to issue any order that would send a child into the criminal court system in any way. So I would say it's both.
Okay, right, thanks.
The next question was about the capacity of rehabilitative programs. And there's a lot to say about that because it's sort of a broad question. And that's because there's so many services that are considered rehabilitative programs. I mean, from my perspective, schooling, education is rehabilitative programming for my clients. If I can do something as simple as take a client who's struggling in school, not attending school, not engaging in school, and get them onto a successful track in school, I consider that rehabilitating. So it is a broad question. I will say that generally, the experience of our attorneys is we're not having problems getting services in the community. So our clients that need adolescent mental health treatment is a little dicey. That's one where I would say we usually get what we need, but we often have to hunt around and find it. But in terms of evaluations, in terms of adolescent substance use treatment has gotten a lot better in the last few years. Being able to get basic, essentially therapy and counseling for kids that need that sort of, just a sort of low level mental health intervention, that's worked great. Things get trickier as you move up the continuum of need. We have long plays getting kids into more specialized programs. That's really where we have kids who need something residential, where they have an issue that needs to be treated in a residential setting. The residential programs have not yet recovered from the pandemic in the way that we would hope. During the pandemic, residential programs were closing entirely, and the ones that stayed open were cutting the number of beds they had dramatically, and it was largely due to staffing. They all have licensing requirements that require X number of staff per bed. And when they don't have the staff, that means they have to close beds. And they have not recovered from that after the pandemic. So we have programs that used to have, capacities of 20 kids, 30 kids that are currently operating and only taking in 10 or 15 kids. And that is really important because what happens at that sort of intermediate tier when you're above the sort of community level of treatment, but you're below the sort of highest level of intervention is so important because it drives everything that happens at the highest level of intervention. As the attorney who represented kids at Woodside, one of the patterns that we saw all the time at Woodside, the most depressing thing you'd see would be an administrative discharge hearing where everybody would agree. DCF administration, Woodside staff, clinicians, the attorneys, everybody would agree that the kid was ready to leave Woodside. They had done well, their behavior had improved, and they were achieving what they needed to achieve, and they weren't going to get anything more out of the program that was offered there. But there would be no bed available for them to go to, and they would stay at Woodside for additional weeks, additional months, and eventually they would decompensate. And eventually they would no longer be in a situation where they were ready to step down from that high level program. And so from our perspective, one of the biggest crises in the juvenile justice system is not what's happening at the top end, secure treatment and placement in locked facilities. And it's not what's happening at the bottom end where most people receive their treatment in the community. It's that middle tier that we have the greatest concern about, because has everything to do with whether kids are successful and manage to sort of step down into community-based treatment, or whether they're unsuccessful and wind up stepping up into really expensive, really invasive, locked, secure treatment that removes kids from their families, from their schools, from their communities. Sometimes is necessary, but we try to avoid that. And I just wanted to add this as sort of a tag on the end, because there's been a lot of questions about Red Clover. It just opened 2 months ago. And I just want to say that our experience with Red Clover has been overwhelmingly positive. I do want to say the building, it's a crappy old building. It's not a good building. Other than the building, the program has been really excellent to work with, really excellent for our clients, and really, I think, has a very appropriate focus on safety and security and identifying when they need to, when do you be in this really secure environment? And when are they ready to move out, and getting them out as quickly as they can when they're ready to move out, which from our perspective is the most important thing.
Yes, Representative Arsenal.
Go ahead.
Oh, okay, thank you.
Oh, sorry.
No, that's okay. Trying to figure out exactly how to ask this question. So, one of the things that you've highlighted is that need for that medium level, and I think we hear that over and over again, not just in juvenile justice, but in mental health and in other disability services and services for older Vermonters as well. And so, thank you. I mean, it's an underlying fact that we need to pay more attention to that, substance use services as well. That same sort of middle level of, the community-based stuff is going okay, pretty good access. The high level stuff, people rush to develop that and, put a lot of money into it. And then that medium level. So yesterday we heard from a witness referred to secure settings for juveniles as incarcerative settings, and referred to it essentially as incarceration. And I guess I'm trying to get a sense, because what I see in the words and hear you say is that you've had some good experiences for your clients in terms of the rehabilitation and sort of like thinking about what their future might be in a different way in some of those settings. And do you view them as a necessary element of, a complete continuum of care? Or do you think that, I guess that's just the question. Do you view them as an element of that?
Absolutely. I mean, I will say, as someone who, before I did this work, I was a teacher, and for a while I was also a behavioral interventionist for the Howard Center. And so I have some experience working with this population of kids. And from my perspective, we do have kids who get into states of crisis that cannot be safely de-escalated in a non-secure setting. I think there's a lot of debate it's legitimate, about do we need non-secure settings to extend beyond crisis de-escalation? That's something that's very much, I think, a legitimate area of debate. It's being debated around the country right now, but I don't think there's a lot of debate that there are, especially for teenagers who are large, who are physically difficult to safely manage. There are states of crisis that require a secure setting for de-escalation. As far as do we need to be providing long-term secure treatment, in my opinion, I've seen the cases where I think long-term secure treatment is beneficial. I think they're few and far between, and I think most everybody agrees with that. I think we dispute sometimes how few and far between they are. But I think, there are cases where I think I've had clients who have been served better in a secure treatment facility than they would have been in a non-secure treatment facility. I think I've had clients who ping pong back and forth between, every time they hit a non-secure facility, they've blown out of it and landed back in a secure facility. And that, constant transition is not therapeutically valuable for anybody. You need some stability. I hate it when the only place we can create stability is in a locked system. But if it's all we've got, if that's the only way we can create stability, then that's what we got to do in order to provide the treatment. Because you can't provide effective treatment to kids who are just bouncing around the system.
Thank you.
I just want to make sure that, check my understanding. So do you count Red Clover as one of those mid-level? That's still higher level.
Red Clover is a locked facility. You go in through essentially a sally port. It is surrounded by fencing. There is no access to non-secure areas by the residents there. And so that's not even from my perspective, by definition, that's a secure facility. It's a secure facility that is providing great educational services and mental health services that are in some cases better than what's being provided at the less secure tiers of treatment.
Right. But officially it's a short, like it's a, crisis stabilization.
I don't think anybody's described it as that. I think
Okay.
people have described it as short-term. I kind of reject the short-term, long-term distinction. When I worked at Woodside, they had a short-term wing that was full of kids who had been there longer than the kids who were in the long-term wing. And they had kids in the long-term wing who were being treated more like detentioners in the short-term wing. It didn't really make sense. So I've never really, that short-term, long-term distinction is one that I started out trying to use, but I abandoned pretty quickly in my practice.
Well, I don't mean to like dwell on this, but I don't feel like I have a good understanding of what what this middle level is that we're talking about. And maybe this is more, it's more human services, but just to understand like
I'll
what
give
we
you some
should be
examples.
advocating for.
So, sort of the ones that are used really commonly in Vermont would be like Vermont School for Girls in Bennington is a Beckett residential program. Then there's 204 and 206 Depot Street that are also in Bennington. Those are sort of short-term behavioral health stabilization, but not locked facilities. Those ones are actually what I would call semi-secure. They have time delays on the doors. So if you try to run from Depot Street, you hit the door and an alarm goes off for 30 seconds before the door opens up. So it gives staff time to come and get you. But it's technically it's not a locked facility. The programs that are run by Laraway up in Lamoille County, and the Washington County Mental Health group homes and micro residential facilities. Some of the programs that are and have been run by Spectrum over the years. It's that sort of what we would call group homes, congregate care facilities, residential treatment centers, all of those I would consider to be that middle tier. Anything where the doors don't lock behind you when you walk in.
Thank you.
I think you got logged off.
I think I did too.
But at least I think we're still being heard.
Join back in here.
Tell me how.
Sorry, I don't know why it logged me off.
30 seconds.
Slide.
You're set to share again.
Okay, hey, is my screen here? There we go. So, moving on to the next one. What happens if a juvenile is not meeting conditions? This is a really broad question because there are 3 different types of conditions off the top of my head that a child might not be meeting. And it's sort of a different process for each. So, to begin with, conditions of release. At the beginning of a case, at that arraignment, that preliminary hearing, judges often set conditions of release. I would say in most cases, judges set conditions of release. They're different than conditions of probation. They're not part of the disposition. They're not based on, here's what your needs are. They're based on, what do we need to do in order to keep you and the community safe until we reach the point where we figure out what your needs are and identify the services. And so the court can set conditions of release, and if a child violates those conditions of release, they may be charged with a whole new crime. They may be taken into DCF custody. So most, like I said, the vast majority of young people are released into their family's custody. But if they are committing repeated violations of conditions of release, that would be grounds for the state to come in and say, you know what? we want this kid to come into state custody. We don't want this kid to remain in their home. So that's, another option that a judge would have is to place the kid in state custody. And then sort of the highest option would be if the kid is continuing to commit violations of conditions of release, then the judge can send the kid to Red Clover. Courts have the authority in the pretrial phase of a case to simply order a child into Red Clover, Vermont secure detention.
Very different than the criminal justice system where you can't detain somebody just because they're violating conditions of release, right?
It is different than, yes, it is easier because in the juvenile justice system, taking custody of a child is a very different situation than custody of an adult. And this is actually one of the things came up a bit in yesterday's testimony from DCF in a way that was maybe not explained super clearly, but when DCF takes custody, they take custody as a parent, as a guardian. They take full custody. And that's actually really different than in other states. In other states, delinquency custody is treated the same as corrections custody. So when DOC takes custody of somebody, they don't take parental custody. They're not in charge of that person's healthcare decisions or their educational decisions or their religious decisions or anything like that. They just take physical custody. When DCF takes custody, they take full custody. They are in charge of medical decisions, religious decisions, educational decisions, all of that. It's not just simply having physical custody of the child. And so what that means is DCF has the ability to, when they have a kid in custody, to place that child in different placements just as a matter of discretion. So just like as a parent, if I wanted to take my child, if my child was misbehaving, which neither of them are, they could, they're 13 and they're 17 and 20, so there's definitely that potential. If they were misbehaving, not the 20-year-old because she's an adult, but the 17-year-old, I could say, you know what, we are putting you in a program for misbehaving children. Or I could say, you know what, you really need to be away from the group of friends that you're around right now, and I'm going to send you to live with your grandma for a few months. And these are all the same kinds of things that DCF can do when DCF has custody. They can do all that same stuff. They can say, you know what, we think things are really unstable and are destabilizing you at home, so we're going to put you with family, with your extended family. Or they can say, we're going to put you in foster care. Or they can say, we're going to put you in a treatment program. They have a lot of control.
So just real quick, so DCF has to take custody before they would make the step of detention?
Yes, but that is often a simple, if a child is violating their conditions of release and DCF goes to court and requests custody and a 5291 order, which is an order placing a child in a secure program, it's a one hearing event. They show up and say, here's what we want and why we want it. Violating these conditions, there's a brief hearing, and if the judge orders it, then the child is in DCF custody and placed at Red Clover.
And not to put too fine a point on it, but that shows that there's some accountability for that individual, for that juvenile pre-merits hearing and such.
Yeah, definitely. It's, pre-merits. We have a lot of kids who are either detained or removed from their home in some way or another pre-merits.
Marshall, can I just,
yes.
So one of the things that our committee has heard about over the last couple of years, well, honestly, since Woodside closed, is the use of, DCF staff, social workers, caseworkers, and, honestly, lots of different people, to, I don't know what to call it, just sit with, to staff up in hotel rooms, in, offices around the state and stuff like that. What are you seeing from your client's perspective about that? Are you seeing the continued use of that? Has that diminished some?
That has diminished tremendously. In fact, it's not as if I get a report every time it happens, but I certainly hear about it most of the times that it happens. because we don't like it any more than DCF likes it. From our perspective, it's putting our clients in danger. Like it's really an inappropriate setting for, it's usually used for clients who are in crisis. That's why it's being used. And it's almost the least appropriate setting for a client in crisis is to be alone in a really sort of non-therapeutic space with somebody who's really there only to keep you safe, not to provide any sort of therapeutic or de-escalatory type of services. And it's not safe for the DCF staff. It's not safe for anybody. It is something that I'm horrified that we've ever had to employ. And I haven't heard about it in a little while, and I hope that we never hear about it again.
Thank you.
So conditions of probation are separate. This is what happens after disposition. So at disposition, in almost every case, a judge is going to put a child on some conditions of probation. And there's a bunch of different ways that violations of conditions of probation get addressed. First of all, DCF works with kids on minor violations. It's not like every time, because these violations, conditions for children are pretty extensive, and we kind of even accept the fact that they're going to violate some of the conditions. One of the regular conditions is obey the rules imposed by your parents, right? Of course, no child is going to comply with that condition perfectly. And that's why really the first line for those minor violations is DCF working with the child. So if somebody's parents call up and say, my kid's not listening to me, come and deal with this, DCF will step in and say, look, you really have to follow the rules at home or you're going to get in a lot of trouble. Let's work with you to see, like, why did this happen? What can we do? And they might impose a graduated sanction, something small. They might say, you know what? For the next week, you're going to have a curfew where you didn't have a curfew before. Or for the next week, your curfew was 9 o'clock, but we're going to shrink it down to 6 o'clock because, you're getting a little bit out of control and we want to give you some structure here. So that's the kind of informal graduated sanction process that DCF often starts with for minor violations. If the violation is more serious, it's charged in court. And in court, there's a lot of different things the judge can do if they find that probation's been violated. They can impose new probation conditions. So for example, if I have a client who violates their probation by using illegal drugs and because they tested positive on a urinalysis, and we have a hearing and my client is found to have violated, judge might be a really typical response to say, you know what, since we've got this problem with you going out and doing stuff after school, your condition is good. You're gonna have a new condition, which is you have a 4 p.m. curfew. You have to go straight home after school. You can't be out on the streets after school. Simple response. It might be more serious than that. It might be to add a condition that says you have to engage in substance abuse treatment. It might be to extend the term of probation so that the youth is on probation longer. It might be to change custody. If the kid was at home and violating their conditions of probation, they might be shifted into DCF custody, placed in a foster home, placed in a residential placement, or placed in a secure treatment facility like Red Clover. So that's the responses to violations of probation. And then there's violations of institutional rules. Every youth is in some kind of an institution. They are in school. They are in a treatment facility. They are in community-based treatment. And if you violate the rules at those places, that can change. It can be a violation of probation because usually there is a condition of probation that says follow the rules at your placement. It can also be something that gets you not violated in any way, but kicked out of a placement. And so it can result in a change of placement that might be a really negative experience or a positive experience, depending. So that's really sort of the conditions question. I'll try to keep moving, being aware of the time.
So we're actually gonna take a 10-minute break right now.
Okay.
Just to let people stretch, and then we'll finish up with you after that.
I have a 10:30, in order to make the technology work with Karen, I have to start at 10:30.
Okay, so we'll take a 10-minute break, we'll go to you, and then we'll come back to you for your last slide. That gives you a good kind of break. Is that okay? Will you be able to stick with us?
Absolutely.
All right, so we'll be back at 10:30
The machine and the.
so it's an 8-minute break.